Order, please. À l'ordre. S'il vous plaît. There is no need to rise. Vous n'avez pas besoin de vous lever. This sitting of the Foreign Interference Commission is now in session. Commissioner Hogue is presiding. Cette séance de la Commission sur l'ingérence.
This session on the inquiry into foreign interference is now in session.
En cours.
Bonjour à tous.
Good morning, everyone. Today marks the opening of the first series of public hearings of the Commission of Inquiry into Foreign Interference in federal electoral processes and democratic institutions. These hearings, I would like to acknowledge, are being held on the traditional territory of the Algonquin Anishinaabe people. I would like to take this opportunity to thank the representatives of Public Services and Procurement Canada for their cooperation and availability in organizing the venues in such a way that everyone can work effectively and the public feels welcome. My name is Marie-Josée Roque, and I have been appointed Commissioner to preside over the Commission's work and bring it to a successful conclusion. I usually serve as judge on the Quebec Court of Appeal, and although I will be returning to my duties when the Commission's work is completed, I have been devoting myself entirely to the Commission's work since mid-September. I would like to thank the Chief Justice of Quebec, the Honorable Manon Savard, for agreeing to temporarily relieve me of my duties as a judge. Welcome to you all, wherever you are.
Welcome to you all, whenever you are. Présent dans cette salle, écoutant la télévision ou par web diffusion.
Here in this room, listening on television or via webcast, thank you for your interest in the Commission's work. It demonstrates the importance you attach to our democracy and your commitment to ensuring its protection. I am accompanied today by some of the Commission staff. Ms. Chantona Choudhury is the Commissioner's lead counsel. You will get to know her and appreciate her work. I'm certain about that. Many of the counsel on her team are also here today, and you will have the opportunity to see them in action this week. I'm also accompanied by Professor Geneviève Cartier, our Research Council Chair. Her team has identified experts with the knowledge required to assist the Commission in carrying out its mandate. I will come back to the role of these experts later. I would like to thank them all for their commitment, as well as those who work behind the scenes, executive directors, communications managers, editors, assistants, translators, interpreters, administrative and technical staff, and security personnel. Without them, it would simply be impossible to carry out the mandate entrusted to us.
Before turning to the Commission's intended work, I would like to recall the context that gave rise to its creation, what the role of a Commission of Inquiry is, and the mandate that has been entrusted to us here. I will then give an overview of the work the Commission wants to undertake and how we intend to do it. Allegations that foreign governments are attempting to interfere in Canadian elections have been circulating for some time. But these allegations were particularly prevalent in 2022, when some media outlets reported that they had received information suggesting foreign interference in the 2019 and 2021 federal elections. In the wake of these revelations, some members of Parliament have publicly asserted that they themselves have been the target of foreign interference and that they were not notified about it in good time by Canadian authorities. Given the importance of protecting our democracy, these allegations have sparked significant debate and discussion both at the political level and in the media. Thus, in March 2023, The Government of Canada appointed the Right Honourable David Johnston as independent special rapporteur, asking him to determine whether foreign governments had indeed attempted to influence election results, either by interfering with voters or with the candidate themselves. He was also asked to review, where appropriate, the information and actions taken by the federal government in relation to the threat of foreign interference, and to determine whether it will be advisable to investigate the matter further. Le rapporteur spécial Johnston.
Special Rapporteur Johnston submitted a public report together with a confidential annex on the 23rd of May 2023. In his report, he concluded that foreign governments had attempted to influence candidates and voters in the last two elections, but without compromising the integrity of the elections. He also expressed the opinion that the way the information on this matter had been circulated was problematic, adding, however, that nothing he had seen led to the conclusion that the Prime Minister or any minister or their respective offices had refrained voluntarily or through negligence from acting on information they may have received relating to acts of foreign interference. He recommended that an additional public process, other than a public commission of inquiry given the amount of related classified documents, be undertaken to further examine the threat posed by foreign interference. There is no need to revisit the events that subsequently led to the Special Rapporteur's resignation. Suffice it to say that on the 7th of September 2023, with the agreement of all the recognized political parties, the Government of Canada established by order in council the present Commission of Inquiry and appointed me Commissioner. I took office shortly after on the 18th of September. I would like to say a few words on the nature and role of a Commission of Inquiry. A Commission of Inquiry is a public institution created by the government and entirely independent of it in the pursuit of its work. It has considerable leeway in all its decisions relating to the way it chooses to proceed. It is not bound by conclusions arrived at by others called upon to study similar matters. That being said, the Commission has to carry out its powers as stated in the constitutive mandate while respecting procedural fairness. The role of a Commission of Inquiry is to investigate the facts in order to understand what happened in a given situation. Under its mandate, it carries out an objective search of the truth while identifying specific matters, draws conclusions, and makes recommendations to the government. Subject to some constraints I'll come back to later, those facts are made public.
Investigate the facts in order to understand what happened in a given situation. Its objective is to search for the truth, seeking to understand what happened in order to inform the public and make recommendations to the government. It attempts to identify all relevant facts and then draw conclusions. Subject to certain constraints, to which I will return later, it makes these facts public. Le processus qu'une commission d'enquête applique n'est donc pas.
The process followed by a commission of inquiry is therefore not an adversarial one, like that of a civil or commercial proceeding, nor an accusatory one like that of a criminal trial. It is not the role of a commission of inquiry to seek to identify guilty parties or those responsible. There is no plaintiff or defendant, no accused. That being said, the Commission makes public its observations, even if this may undermine the reputation of some persons and organizations. The Commissioner's lawyer and I are neutral and impartial. We represent the public interest, and our goal is to uncover the truth, whatever it may be.
Neutral and impartial. We represent the public interest, and our goal is to uncover the truth, whatever it may be. You will note throughout its work that the Commission Council will work together with the lawyers of the participants, be they parties or interveners. This is standard practice in the Commission of Inquiry. Everyone must work towards the same goal: understanding what happened, learning from it, and making recommendations for the future. This idea of cooperation is so important that the rules of practice and procedure adopted by the Commission expressly impose an obligation on Council to cooperate with one another. It even goes so far as to provide for the possibility of participants or their lawyers to suggest to Commission Council topics to explore with witnesses or questions to ask them. This cooperation is essential if the Commission is to be effective and make good use of the very limited time at its disposal. That being said, I may choose to allow some interveners or their lawyer, as the case may be, to ask certain witnesses questions on specific subject if I feel, along the way, that it may be useful in better understanding certain facts. This is a discretionary power that I will retain throughout the hearings and exercise as necessary. The applicable rules of evidence are also flexible, as a Commission is not bound to adhere to strict rules of evidence in the same way that courts generally are. This flexibility is just as essential to enable the Commission to effectively carry out its work within the limited time allocated. Thus, I can allow evidence to be presented in multiple ways, provided, of course, that in doing so, I uphold procedural fairness. As Commissioner, I indeed have the obligation to ensure that the rights of all are respected. Since I am presiding over the hearings, and it will be up to me to draw conclusions from the evidence being presented, I want to stress that I have not yet seen that evidence. I have discussed with the Commission Council the subject that seemed relevant to me and the way in which the hearing should be conducted, but I have chosen to participate neither in the meetings with potential witnesses nor in the review of the documents obtained. I have chosen this approach to ensure that I have no preconceived ideas, and I will adhere to it throughout the Commission work. Puisque je préside les audiences et qu'il m'appartiendra...
Since I am presiding over the hearings and it will be up to me to draw conclusions from the evidence being presented, I want to stress that I have not yet seen that evidence. I have discussed with the Commission's lawyers the subjects that seem relevant to me and the way in which the hearings should be conducted, but I have chosen to participate neither in the meetings with potential witnesses nor in the review of the documents obtained. I have chosen this approach to ensure that I have no preconceived ideas and I will adhere to it throughout the Commission's work. That being said, my team and I will make every effort to get to the bottom of things and understand what the country has faced and what it may still be facing in terms of foreign interference. Foreign interference in our democratic institutions is a very serious issue. It requires us to investigate, analyze, and reflect as thoroughly as possible in order to ultimately identify the best ways to counter it, or if it is not possible to prevent it entirely, to limit its effects.
That said, my team and I will make every effort to get to the bottom of things and understand what the country has faced and what it may still be facing in terms of foreign interference. Foreign interference in our democratic institutions is a very serious issue. It requires us to investigate, analyze, and reflect as thoroughly as possible in order to ultimately identify the best ways to counter it, or, if it's not possible to prevent it entirely, to limit its effects. Conformément aux termes du décret, la Commission
In conformity with the terms of the order in council, the Commission, in the first stage of the factual phase of its work, must examine whether China, Russia, or other actors, state or non-state, you probably know that the Commission is also interested in India, interfered in the 2019 and 2021 federal elections. And if so, we must also assess the repercussions that these acts or attempts to interfere may have had on the integrity of the elections, both nationally and at the constituency level. The Commission must then examine, where appropriate, the way in which information obtained in this regard circulated and the measures that could have been taken in response.
In conformity with the terms of the order in council, the Commission, in the first stage of the factual phase of its work, must examine whether China, Russia, or other actors, state or non-state, you probably know that the Commission is also interested by India, interfered in the 2019 and 2021 federal elections. And if so, we must also assess the repercussions that these acts or attempts to interfere may have had on the integrity of the elections, both nationally and at the constituency level. The Commission must then examine, where appropriate, the way in which information obtained in this regard circulated and the measures that could have been taken in response. La Commission rédigera et déposera un premier rapport.
The Commission will draw up and submit a first report on these issues by the 3rd of May at the latest. In the second stage of the factual phase, capacity and means to detect, prevent, and counter foreign interference, paying attention to three main considerations. First, how information is created, exchanged, assessed, and disseminated, and how advice for senior decision makers, including elected officials, is formulated. Secondly, the support and protection measures in place to protect members of a diaspora who may be particularly vulnerable and become the first victims of such interference. Finally, the mechanisms that were in place to protect the 2019 and 2021 elections from foreign interference compared to those that were in place in more recent elections before 2019.
The Commission must analyze the country's capacity and means to detect, prevent, and counter foreign interference, paying attention to three main considerations. First, how information is created, exchanged, assessed, and disseminated, and how advice for senior decision makers, including elected officials, is formulated. Secondly, the support and protection measures in place to protect members of a diaspora who may be particularly vulnerable and become the first victims of such interference. Finally, the mechanisms that were in place to protect the 2019 and 2021 elections from foreign interference compared to those that were in place in more recent elections. Finally, in the policy phase of its work, the Commission will think of ways to ameliorate states' capacity to detect, prevent, and counter foreign interference, as well as, if applicable, ways in which relevant information is communicated to interested persons and then formulate recommendations.
Finally, in the policy phase of its work, the Commission will think of ways to improve the state's capacity to detect, prevent, and counter foreign interference, as well as, if applicable, ways in which relevant information is communicated to interested persons and then formulate recommendations. The Commission will draw up a second report on this subject, which, in addition to its factual conclusions, would include all of these recommendations regarding the issues raised in its mandate. This report must be submitted no later than the 31st of December 2024. The Commission is thus facing two major challenges: the time available to it and the fact that the vast majority of documents and information to which we will have access in the course of our work and on which we will base our conclusions are likely to be so-called classified documents. The limited time that it has and provided for in its mandate is there, but there's also the need to quickly study the matter of foreign interference and think of ways of quickly formulating recommendations to increase the government's capacity to detect it and to counter it. If that time constraint can be lifted through the collaboration work we've mentioned that related to the processing of classified documents, this would require specific work. And this is what we'll be delving into in the next week. When we talk about intelligence and classified information, we are talking about documents and information that cannot be made public. But a public inquiry, as the name indicates, is intended to clarify the public. The mandate that was given to it requires a fundamental duality: respect the laws and regulations that are applied to classified information and maximize the transparency of its deliberations. Luckily, the inquiry will be resorting to lots of experienced counsel who are experienced in evidence when it comes to classified documents and intelligence, and some of them have been recognized by the Federal Court for acting as amicus curiae, friends of the court, when this court had to resolve disputes in this matter, specifically to determine the challenges, limitations, and the possible dangers related to public disclosure of classified information and intelligence related to national security. The order in council requires that there be some in-camera deliberations. These are preliminary deliberations related to national security confidentiality, and this is what we'll be doing this week. Why describe it as preliminary hearings? Because this would help prepare subsequent public hearings which will deal with the substantive issues. Furthermore, presentations, discussions, and testimony that will take place this week will be only about the challenge that is national safety in the context of a commission of inquiry and not on substantive issues.
The work we will undertake this week consists of first understanding the constraints arising from the fact that many of the relevant pieces of information and documents are classified, and secondly, considering the best ways for the Commission to make public as much information as possible during the hearings of stages 1 and 2 and in its reports. During these preliminary hearings, we will hear from factual witnesses and recognized experts who, as we wrote in our second notice to the public, will help the Commission and the public understand both the risk that may arise from the disclosure of classified information and the practices that can be adopted to allow the disclosure of as much information as possible, while adhering to applicable legal and national security constraints. Here is what we are considering as a work schedule, subject, of course, to what we discover in the course of the inquiry. Let us first clarify that the two phases of the work, which I referred to earlier, cannot be completely separated from each other. The investigation that has begun and the evidence that will be introduced at each series of public hearings, whether they relate to stage 1 or stage 2, can and will certainly be useful in enabling us to understand the situation in its entirety. Based on what we hear during this week's hearings, the Commission will work to make disclosable the classified documents and information it has already received and will continue to receive as it carries on with the inquiry concurrently. And I should say, as much as possible. À la lumière de ce qu'elle aura entendu lors des audiences,
Based on what we hear during this week's hearings, the Commission will work to make disclosable the classified documents and information it has already received and will continue to receive as it carries out with the inquiry concurrently.
we will again hold public hearings, probably at the end of March 2024, which will focus on the issue raised in the first phase of our work. La Commission devra-t-elle également tenir...
The Commission will also hold in-camera hearings as provided for in its mandate, considering the amount of classified information. It is very likely that will happen. That being said, the Commission will try to find ways to communicate the essence of the information obtained, for instance, by means of summary. It is also possible that certain persons called upon to testify before the Commission who fear for their safety or the safety of members of their family request that their identity be protected or certain information provided be kept confidential. Such requests may lead to the need for in-camera hearings.
Persons called upon to testify before the Commission who fear for their safety or the safety of members of their family request that their identity be protected and/or certain information provided be kept confidential. Such requests may lead to a need to hold in-camera hearings. À cet égard, je rappelle que la Commission...
In this respect, I would like to point out that the Commission has adopted rules of practice and procedure which contain a number of measures designed to safeguard those who provide us with information. These rules, though technical in nature, are well worth consulting for those interested in the Commission's work. They are available on the Commission's website under Documents. As for measures that may be taken to safeguard certain individuals, please refer specifically to Rules 51 and 82 to 85. We must retain the fact that the Commission is very aware of the fact that we may need to protect the identity of some witnesses or some information that citizens or groups share with the Commission. Those who ask that the identity be protected would have made that request before their testimony or before providing information.
Remember is that the Commission is well aware that it may be necessary to protect the identity of certain witnesses or certain information that citizens or groups will communicate, and that I will not hesitate to do so when I deem it appropriate. In fact, those who request that their identity be protected will know of my decision in this regard before they undertake to testify or provide information and documents. J'ai par ailleurs l'intention d'assurer le respect.
It is also my intention to ensure that everyone's rights are respected during in-camera hearings. Therefore, I may choose to limit the scope of testimony or to disregard certain information that may be communicated to me during such hearings in private if I deem it necessary in order not to jeopardize the reputation or rights of citizens who, it must be said, will not in such circumstances have the opportunity to submit said testimony or information to cross-examination. I would also like to remind you that testifying will not be the only means available for relaying information to the Commission. The Commission intends to set up a process that will enable all those who wish to do so to submit their comments and suggestions to the Commission and to share relevant experiences they may have in relation to issues within the Commission's mandate. This process will be user-friendly and will allow those communicating information in this way to request that their identity and certain shared information be protected.
An email address to facilitate sharing of confidential information. Strict measures have been put in place to protect the confidentiality of information sent via the email address, also available on the Commission website. At present, it is planned that the public hearings during which the Commission will examine the country's capacity and means to detect, prevent, and counter foreign interference, stage 2, will take place in September 2024. The factual investigation of stage 2 will take place and will be followed by hearings on the policy phase of the Commission, which will bring to light the Research Council's work. Further details about the Council members may be found on the website. Concurrently and throughout its work, the Commission will collaborate closely with the Research Directorate, which has set up a Research Council made up of 4 academics whose combined skills cover all aspects of the Commission's mandate. The Council's role is to design and implement a research program that will support the Commission in all aspects of its mandate. Experts will then be invited to produce reports or take part in public roundtable discussions with the aim of providing the insights the Commission needs, in particular with a view to submitting to the government relevant and realistic recommendations on ways to detect and counter interference, or at the very least, to minimize its impacts. For the time being, however, we must get on with our preliminary hearings, and to do so, I give the floor to Mrs. Chaudhuri. Thank you.
Thank you, Commissioner. Good morning, everyone. My name is Shantona Chaudhuri, and I am lead counsel to the Foreign Interference Commission. Bonjour tout le monde, je m'appelle Shantona Chaudhuri, et je suis...
Good morning, everyone. My name is Shantona Chaudhuri. I'm lead counsel for the Foreign Interference Commission.
Here today, in person and remotely, by a number of Commission counsel who've been working very hard to put this week's hearings together in a very short time. Gordon Cameron, Aaron Dan, Jean-Philippe Maquet, Natalia Rodriguez, Daniel Shepard, Hannah Lazar, Siobhan Morris, and Nicolas Saint-Amour. As the Commissioner explained, this week's preliminary hearings are mandated by Clause A1D of the Commission's Terms of Reference, which direct the Commission to hold public hearings at the outset of its mandate on national security confidentiality. It is important to understand that this week is not yet about the actual substance of the Commission's mandate. The Commission's investigation is ongoing. We will, of course, have public hearings in due course. As the Commissioner mentioned, we anticipate holding those hearings in late March with respect to clauses A1A and A1B of the Terms of Reference, and in September with respect to clause A1C. But for this week, the topic at hand is national security confidentiality. Over the course of the week, we will be hearing from experts, former officials, and current fact witnesses in an effort to explore the challenges involved in dealing with classified information, and importantly, to identify how the Commission can best meet those challenges.
I will now present a general overlook of the schedule for the week. Today's day is about an introduction. We are asking all the participants or their lawyers to introduce themselves. Then the lawyers of the Commission will make 2 presentations. The first one will be about the general operation of commissions of inquiry in general, and more specifically, the functioning of this commission. The second phase will cover, the second presentation will tackle the issue of confidentiality around national security by dealing with some concepts that will be explored more in detail this week. Tuesday and Wednesday will be dedicated to expert consultations, whereas Thursday and Friday will be reserved to depose witnesses on facts. On Tuesday, we will hear a panel of university scholars specialized in relevant topics such as national security, law, and the right to information. Professors Leah West, Michael Nesbitt, and Pierre Trudel will intervene. It will be a moderated discussion followed by a question-answer session, both moderated by the Commission's lawyers. On Wednesday, we will hear a certain number of former heads of national security and the community of intelligence, John Forrester, former chief of the Telecommunications Security Center, or CST, Richard Fadden, former chief of the Canadian Intelligence Service, and former head of national security with the Prime Minister, as well as Alan Jones, former deputy director of the operations at CSIS. Once again, this format will be that of a discussion followed by a question-and-answer session moderated by a commission lawyer.
A panel of CARD officials in the national security and intelligence community will testify. David Vigneault, Director of the Canadian Security Intelligence Service, CSIS, Alia Tayeb, Deputy Chief of Signals Intelligence at the Communications Security Establishment, or CSE, and Dan Rogers, Deputy National Security Intelligence Advisor to the Prime Minister. The witnesses will be examined by Commission Counsel, followed by cross-examination by the parties. On Friday morning, Dominique Leblanc, Minister of Public Safety, Democratic Institutions, and Intergovernmental Affairs will testify. He too will be examined by Commission Counsel, followed by cross-examination by the parties. On Friday afternoon, the Commissioner will hear closing submissions from the participants, and that will conclude the week. Sur ce, j'aimerais vous remercier.
Upon this, I would like to thank you on behalf of the Commission for being here with us, to be listening to us, and mainly for your will to help the Commission to accomplish its mandate that is very important and very demanding. Thank you.
Thank you. So I now invite the participants or their lawyers to introduce themselves. In the case of association or organization, I will appreciate that you indicate which interests you represent. The Commission already knows, but I think it's a good idea for everyone attending the hearings to know it too. So let's start with the Government of Canada.
Bonjour, Madame la Commissaire.
Good morning, Mrs. Commissioner, councillors, and lead counsel. I am Gregory Chapanikis, and with my colleague Barney Brooker, we are the lead lawyers for the Government of Canada. We also have Alison Lee with us.
Very brief introductory observations. First, it is foundational to Canada's democracy that Canadians have confidence in free and fair elections. The Government of Canada is committed to supporting the work of the inquiry and in reinforcing the confidence of Canadians. Second, as we enter into these hearings on the challenges posed by dealing with largely classified information, we will offer a perspective that looks at the full range of public interests, including ensuring that Canadians are well informed of the risks of foreign interference. There are tools that would allow us to achieve this goal while upholding the public interest in protecting certain categories of information. Merci.
Merci beaucoup.
Thank you very much.
So we can go on with the Office of the Commissioner of Canada Elections.
Bonjour, je m'appelle Christina.
Hello, I am Christina Mailleux, and I'm Strategic Advisor and Lead Counsel at the Office of the Commissioner of Canada Elections, who will be acting as a participant for both stages. I will be accompanied over the next few days by my colleague Luc Boucher, who is not here today. The Commissioner of Canada Elections is the independent representative to make sure that the federal law is applied in Canada. Foreign interference in democratic federal processes is a challenge that the Commissioner of Canada Elections, Caroline Simard, takes very seriously. The BCEF thanks the Commissioner for the opportunity that we have in participating. We are happy to contribute and collaborate in realizing this important mandate. Thank you. Thank you very much.
The Human Rights Coalitions.
Commissioner Hoag, participants and fellow council, valued members of the media and the public. My name is Hannah Taylor, counsel for the Human Rights Coalition. My pronouns are she or they, and I can be referred to as Ms. Taylor or Counsel Taylor. My co-counsel for these hearings is David Matus, sitting to my right, whose pronouns are he, him, and who can be referred to as Mr. Matus. The Human Rights Coalition is comprised of 8 community organizations engaged in work for the rights of several diaspora communities, particularly vulnerable to transnational repression and the effects of foreign interference in Canada. These organizations are Human Rights Action Group, Uyghur Rights Advocacy Project, Falun Gong Human Rights Group, Canada-Hong Kong Link, Democratic Spaces, Hidmona Eritrean Canadians Human Rights Group of Manitoba, Security and Justice for Tigrayans Canada, and the Alliance of Genocide Victim Communities. Thank you for the opportunity to participate in the Commission's work.
Thank you. Let's go now with the Russian-Canadian Democratic Alliance.
Good morning. I'm Guillaume Serrois from Power Law. I will be representing the Russian-Canadian Democratic Alliance before the Commission, along with my colleague Mark Power. The RCDA's core mission is to support the development of the Russian-Canadian community around the ideals of democracy, human rights, civil liberties, and the rule of law. Regarding the national security confidentiality hearings, the RCDA is concerned that no witnesses from the diaspora will be heard. Comme l'a souligné la commissaire dans son discours d'ouverture.
As the Commission underlined in its opening speech, members of diaspora are the first victims of foreign interference. They have the most interest in having more information about this threat and on the actions of the government in response to this threat. The Russian-Canadian Democratic Alliance will hope that the Commission will meet its mandate to maximize transparency for the public. But this transparency should restore public trust in its democratic institutions, but it also give to the diaspora critical information to better protect itself against foreign interference. Thank you. Thank you. Mr. Sirois.
The Ukrainian Canadian Congress, I think they are on the video.
Good morning, Commission.
Good morning.
My name is John Duty. I represent the Ukrainian Canadian Congress along with Donald Bain. The Ukrainian Canadian Congress is the voice of Canada's Ukrainian community. It's an umbrella organization representing the national, provincial, and local Ukrainian organizations within Canada. And our interest is particular in how Russia's interference has impacted Ukrainian Canadians specifically. Thank you.
Thank you. Michael Chung.
Bonjour, Madame la Commissaire.
Hello, Mrs. Commissioner.
Is Fraser Harland, and we are counsel for the Honourable Michael Chong, MP.
Ann Dung.
Good morning, Commissioner. I'm Mark Pauley, and I'm accompanied by Jeffrey Wang and also online by Emily Young. And we represent the Honourable MP Han Dong. Thank you.
Thank you. Jenny Kwan.
Good morning, Commissioner. My name is Sujit Chaudhary. I'm counsel for Jenny Kwan, Member of Parliament for Vancouver East. I'm joined by my co-counsel, Mani Kakkar. Thank you.
Thank you. The Michael Chan, I think, is on video, or is counsel.
Yeah, yes, Madam Commissioner. It's John Chapman. I and my colleague Andy Chan represent Mr. Chan, and Andy is on Zoom as well.
Thank you. Then we have the Center for Free Expression.
Yes, good morning, Commissioner. My name is John Mather. I'm attending this morning with my colleague Michael Robson. We represent the Center for Free Expression. The CFE is a nonpartisan research, public education, and advocacy center based out of the Toronto Metropolitan University. Among other things, the CFE advocates for the public's right to information about its government and public institutions. The right to information is a fundamental component of the right to free expression. If Canadians are deprived of information about their government, there cannot be informed public discourse, and informed public discourse is a foundation of genuine democracy. The CFE welcomes and thanks the Commissioner for the opportunity to participate in the Commission's process and to assist the Commission in achieving its mandate to maximize transparency. Transparency is necessary to ensure Canadians have confidence in their elections. Canadians have the right to know what happened, how their government responded, and the ongoing threats that may persist. And we hope through this process that the Canadians will not be left in the dark. Thank you.
Thank you. The Churchill Society. It's on video, I think.
Yes. Good morning, Madam Commissioner and Commission Council. My name is Maliha Wilson. You can refer to me as Ms. Wilson or Council Wilson. The Churchill Society for the Advancement of Parliamentary Democracy is a non-partisan charitable organization that facilitates discussion and debate about Canada's parliamentary democracy. Our work celebrates and upholds the integrity of democratic institutions, and our direct interest in this inquiry stems from that work, and our participation will serve as a bulwark against the erosion of public confidence in these institutions by reassuring our many supporters that our voice is heard. Thank you.
Thank you. The Pillar Society.
Good morning, Commissioner. Bonjour à tous. I'm Dan Stanton. I'm on the board of directors of the Pillar Society. Formed in 1994, the Pillar Society is an organization of former members of the Canadian Security Intelligence Service and members of the former RCMP Security Service. We have a very particular set of skills relating to intelligence collection, human source assessment and protection, as well as the disclosure of intelligence and the intelligence to evidence challenge. As noted by the Commissioner in her rationale for accepting Pillar's application, and I quote, as former members of Canada's intelligence community, Pillar Society members may offer a different perspective than current representatives of CSIS and other government bodies. I acknowledge that the Pillar Society may present a different perspective on a range of intelligence and machinery of government issues, and that the Commission would benefit from diverse viewpoints. The Pillar Society is very honored and enthusiastic about participating in this inquiry.
Thank you. Democracy Watch.
Good morning, Madam Commissioner. My name is Wade Poziemka, and I, along with my colleague Nick Papageorge, represent Democracy Watch, a national nonprofit and nonpartisan organization advocating for democratic reform, government accountability, and corporate responsibility.
The Conservative Party of Canada, I think on video.
Good morning, Madam Commissioner. My name is Nando DeLuca. I'm appearing on behalf of the Conservative Party of Canada.
Good morning, thank you. The Chinese Canadian Concern Group on the Chinese Communist Party's human rights violations.
Good morning, Madam Commissioner, Commission Council, participants and council. My name is Neil Chantler, and I am counsel for the Chinese Canadian Concern Group on the Chinese Communist Party's human rights violations. The Concern Group is a grassroots organization formed in 2020. Its members are Hong Kong immigrants to Canada with a wide range of backgrounds and professions, including journalists, professors, engineers, and religious leaders, many of whom have been the target of foreign interference. The Concern Group's mission is to observe and expose human rights violations by the Chinese Communist Party and China's influence on Canada's political, economic, and academic arenas. The Concern Group looks forward to contributing to this inquiry and has been granted intervener standing in the fact-finding phase and standing in the policy phase of the inquiry. Thank you.
Thank you. Senator Paul Wu, I think on video.
Bonjour, Madame la Commissaire. Je suis.
Hello, Mrs. Commissioner. I am an independent senator representing British Columbia.
I'm very pleased to be part of this commission and look forward to working with all of you.
Thank you. Erin O'Toole, I think his counsel is on video.
Good morning, Commissioner. My name is Tom Jarman, and along with my colleague Preston Lim, we represent the Honourable Aaron O'Toole. Mr. O'Toole was first elected a Member of Parliament for Durham in 2012 and was the leader of the Conservative Party of Canada during the 2021 election. And we look forward to participating in this process. Thank you.
Thank you. The Media Coalition.
Bonjour, Madame la Commissaire, Christian Leblanc.
Hello, Mrs. Commissioner, Christian Leblanc. I am accompanied by Christian Hainaut, and we will be there today and tomorrow. The Media Coalition is formed by CTV Global, Doorstar, CBC Radio-Canada, Québécois Media, and La Presse newspaper.
And as much as we can, guide the Commission on what we think are very important principle of publicity and on confidentiality matters. We know that the Commission is very keenly aware of that, and I'm glad that it was repeated this morning. And we will be here to make sure and defend the right of the public to information and at the disposal of the Commission to do so.
Merci, Mr. Blanc.
Thank you, Mr. Blanc.
And I think the last one is the NDP, but they are not present this morning, if I'm right. Okay. Did I cover everyone, or am I missing anyone? I don't think so. Just think everyone has been covered. Perfect. So we'll go on, and I realize I don't have the. Is it time for the break? I think so, huh? Because it's 10:54 here. Okay, so we'll take the break.
We are now in recess for 10 minutes, or 20 minutes.
Order, please. À l'ordre, s'il vous plaît. The sitting of the Foreign Interference Commission is back in session. Cette séance de la Commission.
The sitting of the Foreign Interference Commission is back in session.
So I would invite Maître Natalia Rodriguez to come to the podium, I think, to make the first presentation.
Thank you, Madam Commissioner. Good morning, everyone. My name is Natalia Rodriguez, and I'm Commission Counsel. Today's presentation will be an overview of commissions of inquiry generally, and also a look into the Foreign Interference Commission specifically. If any of the participants have any questions about this presentation or the presentation that will follow in the afternoon, please feel free to email the Commission with any questions. So, as an overview, I will be looking at the mandate of the Foreign Interference Commission, the history of commissions of inquiry, different types of commissions of inquiry, the fact of the fundamental principle of independence that all commissions enjoy, the type of process, which is inquisitorial and not litigation in nature, the usefulness of commissions of inquiry. I will also then look at some other investigative or policy inquiries as compared to commissions of inquiry. And then finally, we will take a look at the Foreign Interference Commission and some of the characteristics of this commission in particular. Just having a little technical difficulties with the clicker. Oh, there we go. Thank you very much. So to start, the Foreign Interference Commission has an overarching mandate to examine and assess foreign interference in federal electoral processes and democratic institutions, particularly with respect to the 2019 and 2021 general elections, and to make recommendations with respect to that mandate to the government. Commissions of inquiry have a long history in Canada. In fact, the Federal Inquiries Act was enacted in 1867. So since Confederation, there have been 373 federal commissions of inquiry, including this one. So this is number 373. And commissions of inquiry have covered and looked into many of the most pressing issues of those times, including inflation, health, the environment, pipelines, terrorism, and missing and murdered Indigenous women and girls. There are three different types of commissions of inquiry. The first is investigative inquiries, and those make findings of fact about an incident or an institutional or systemic problem, for example, allegations of corruption, and they propose recommendations based on those fact findings to government. This type of inquiry is set up to investigate a past event or a series of events. And as the Supreme Court of Canada said in 1995, it is often in the wake of public shock, horror, disillusionment, or skepticism in order to uncover the truth. This type of commission of inquiry examines the conduct of individuals and organizations that may be relevant to past events. And the mandate and purpose here is to explain what went wrong and why. It's not to ascribe any kind of liability, civil, criminal, or otherwise. Now, the second type of commissions of inquiry is the policy inquiry, for example, the Royal Commission of Aboriginal Peoples. And these are more informal than investigative inquiries. The focus here is on research, consulting, and developing policy options for government. Commissions of this type are mandated to examine a particular area of public policy and to make recommendations for future policy direction. The primary task here is to gather information about an issue and to use it to create a blueprint for future legislation and policy. Now, the third type of commissions of inquiry are the blended commissions of inquiry, which have both an investigative and a policy function. And the last example that we have on the federal front is the Public Order Emergency Commission, which concluded in February of last year. Now, this type of inquiry can be often more complex because it has two completely different stages. And so each stage demands a particular type of evidence and analytical tools. Each requires its own kind of expertise and its own workflow, and sometimes its own dedicated team. So to manage these practical and analytical challenges, the terms of reference, which is the mandate that is given to the Commission by the government, may divide the inquiry's work into two separate phases. The first being a quasi-judicial phase of fact-finding, and the other one is a less legalistic research process to formulate policy recommendations. Now, the Foreign Interference Commission, as you have likely guessed, is a blended type of commission. There is an investigative phase, which is set out in the terms of reference, clause A1A and A1D, A1B and A1C, and there's a policy phase, which is set out in the terms of reference, clause A1E. Now, this Commission of Inquiry is unique in that it also has a third type of stage that doesn't fit quite nicely into the investigative or policy phase, and that's set out in clause D of the terms of reference, which require preliminary hearings into national security confidentiality, and that's what we're doing today. Now, commissions of inquiry are based on a fundamental principle of independence. Commissions of inquiry are established by government, and its terms of reference or its mandate is also provided to the Commission by the government. However, commissions of inquiry are independent from the executive branch and owe allegiance only to the people of Canada. They are nonpartisan, and they carry out their work in an independent, impartial, and neutral manner. They are not beholden to political interests, but rather the work is done in the public interest. Once the terms of reference that are drafted by the government are in place, the government no longer has any control or direction over the process or the procedure of the inquiry. This is unless the terms of reference are amended by order in council. So the Commission receives its mandate and carries out that mandate in an independent manner. Another feature of commissions of inquiry is that they are not part of the justice system. They're not part of the judicial system. They're a different type of process that is not akin to what many lawyers may be familiar with, which is the litigation process. This is not a litigation process. It is not an adversarial process. So in an adversarial system, which is the system that we have here in Canada, there are two advocates, each side representing the interests of one party. And there's also a neutral decision maker who hears arguments from those sides and makes a decision. However, a commission of inquiry is not that. It is more akin to an inquisitorial system, which is used in many civil law systems around the world, including in many European countries, where a judge investigates and decides the case. In this case, a commission is also investigating the facts, although there is no civil or criminal liability, as I mentioned. In the report of the Ippawash inquiry, the commissioner said, a public inquiry is more inquisitorial than adversarial, in that the objective of those involved in the process is to uncover the truth rather than to establish liability. In this case, evidence is called by commission counsel, not by counsel for the parties or the participants. There are no strict rules of evidence like you would have in a courtroom, but there are still principles of fundamental justice that are observed and procedural fairness. Commissioners draft the rules of procedure that govern their inquiries, generally with the input from participants. So again, a very different type of process than litigation. Why are commissions of inquiry useful? Well, they provide an independent and nonpartisan review of events, issues in government. They're able to tackle long-term and complex issues. They're free from many of the institutional impediments or red tape that can sometimes constrain other branches of government, and they're also subject to judicial review. The objectives here are informing and educating the public, politicians, and government, and making recommendations that are aimed at resolving issues and developing policy. Commissions of inquiry have a wide range of investigative powers. Because each commission of inquiry is unique, has a unique mandate, a unique timeline, and is established under unique circumstances, the commission can be staffed with expertise that accord with those specific needs of that commission. Now, there are other bodies and entities that also fulfill a function in our democracy, looking into issues, be they factual issues or policy issues. For example, there are parliamentary committees that often look into some of these issues. There's departmental investigations. The policy branches of government departments also fulfill some of this function. There are government and intergovernmental task forces. Advocacy groups and think tanks often carry out some of this work. And then on the criminal side, there's criminal investigations and prosecutions. However, all of these are very different from commissions of inquiry and serve a slightly different purpose. Parliamentary committees, how do they compare to commissions of inquiry? Well, they can compel evidence like commissions of inquiry can, but they are partisan by nature. So that's one distinction. The work of the parliamentary committee can also die or be dissolved if Parliament is dissolved in the middle of their work. They also have no structured format for questioning witnesses and reviewing documents. Departmental investigations are established under Part 2 of the Inquiries Act. They can also compel evidence. However, they are not independent from government, as they are established and overseen by a government minister. They're normally limited in scope, and the scope is the business of that department and the conduct of official duties in the service of that department. So they're not looking at broader issues beyond those of their department. Departments generally have policy branches, and they also carry out some policy work. However, they do not have the ability to compel evidence. They're not independent from government. There's no public oversight or transparency into what goes on in those departments. And they often are consumed by more urgent, shorter-term tasks and shorter-term issues within the government. And so this may limit their ability to tackle long-term or more complex policy issues. Government and intergovernmental task forces do not have the power to compel evidence, and they are not independent from government. Advocacy groups and think tanks, as I mentioned, sometimes carry out some of this policy work. They do not have the ability to compel evidence. They are often animated by a particular ideological perspective, and they often lack the resource and expertise for effective investigation and policymaking, such as that. Criminal investigations and prosecutions, obviously very different. They focus on individuals' criminal liability in either defending or proving a charge, so very limited in scope. And so those are some other investigatory bodies that carry out similar and at times overlapping work, but have very different features than commissions of inquiry. Now, commissions of inquiry are created and funded by legislation. The Government of Canada, under Section 2 of the Federal Inquiries Act, created the Foreign Interference Commission through an order in council on September 7, 2023. The Inquiries Act allows the Governor and Council to establish an inquiry to investigate any matter connected with the good government or public business of Canada. And this order in council on September 7, 2023 included the terms of reference for this commission. And we'll look at those terms of reference in a little bit more detail. So after the Foreign Interference Commission completes its report and submits it, it does not play any role in implementing any recommendations. There were 4 additional orders in council that relate to this inquiry. 3 of them were made on September 7. The first designated the commission as a funded government department under the Financial Administration Act, which is necessary for funding to have the commission's work go forward. The second amended the Security of Information Act to permanently bind the commissioner and her staff to secrecy under the act. The third amended the Canada Evidence Act to allow the commissioner and staff to review classified information. And there was a final order in council with respect to this inquiry on December 21st, and that extended the first deadline of the first report to May 3rd, 2024. So this chart provides an overview of the terms of reference. As I mentioned, there's a clause A, B, C, D, and E. A, B, and C refer to the factual phase of the inquiry. Clause D relates to these hearings that are being held this week with respect to national security confidentiality. And Clause E sets out the requirement that the commissioner make policy recommendations. So Clause A, as we are probably all familiar with, requires the commissioner to examine and assess interference by China, Russia, and other foreign states or non-state actors with respect to the 2019 and 2021 general elections, as well as any impacts on those elections, and to confirm the integrity of and any potential impacts on those elections. Clause B requires the commissioner to examine and assess with respect to the 2019 and 2021 general elections, the flow of information to senior decision makers, the flow of information between the Security and Intelligence Threats to Elections Task Force and the Critical Election Incident Public Protocol Panel, and to also examine and assess actions taken in response to the flow of information. Clause C requires the commissioner to examine and assess the capacity of relevant federal departments, agencies, institutional structures, and government processes to detect, deter, and counter any form of foreign interference, directly or indirectly targeting Canada's democratic processes, with some specific issues to look at as well, including the effect on members of the diaspora groups. Clause D, as I mentioned, is the clause in the terms of reference that establishes these hearings with respect to classified national security information and intelligence, and to identify challenges, limitations, and potential adverse impacts associating with the disclosure of this type of information to the public. And as I mentioned, Clause E is the clause that requires policy recommendations. So the work of the commission, as we've just seen, is quite vast, and it is divided up into different phases and stages of work. So this chart sets out the different stages in order, chronological order. So on the very left, we have the preliminary hearings that we're conducting this week, and that refers to Clause D of the terms of reference. Next is stage 1 of the fact-finding phase, and that will encompass clauses A and B. So it's looking at foreign interference in the 2019 and 2021 general elections, as well as the flow of information in relation to those elections and foreign interference. After that, the Commission's initial report is due on May 3rd, 2024, and we saw the order in council that extended that deadline. Stage 2 of the fact-finding phase is set out in Clause C of the terms of reference, and that relates to generally the government's capacity to detect, deter, and counter foreign interference, as well as its capacity to protect vulnerable diaspora members and other specific issues. And finally, when that phase is concluded, the fact-finding phase is concluded, the policy phase, which is set out in Clause E, will have its moment to shine, and then a final report is due December 31st, 2024. So while the government provides the Commission with its terms of reference and therefore its scope of work, the Commission establishes the guiding principles, which are akin to a lens through which it will carry out its work. Generally, most commissions of inquiry establish some guiding principles, and these are the ones up here on this slide are the 5 that the Commission on Foreign Interference will be using as its lens through which to guide its work. And these are also set out at paragraph 11 of the Rules of Practice and Procedure. So the first one is transparency. The Commission's proceedings and processes must be as open and available to the public as is reasonably possible, consistent with the requirements of national and personal security and other applicable confidences and privileges. Fairness. The Commission will work to ensure fairness to the public and the participant throughout the proceedings. The Commission will take into account and balance the interests of the public, including the right to be informed, the interests of individuals, and the interests of national security. The Commission will afford fair treatment to all those involved or implicated. Third guiding principle is thoroughness. The Commission will examine the relevant issues with care so that there can be no doubt that the questions raised by the Commission's mandate are explored and answered as thoroughly as possible within the timeframe allocated. Expeditiousness. The Commission is operating under a very tight schedule and must conduct its work accordingly. And finally, proportionality. The Commission will allocate the limited investigative and hearing time available in proportion to the importance and relevance of matters to the Commission's mandate and the relative contributions that the Commissioner determines each participant is able to make to an issue, with the objective of ensuring that the time available to the Commission, which again, I must stress is brief, is directed to properly fulfilling the Commission's mandate. Transparency is of utmost importance in the Foreign Interference Commission. It's a primary objective of commissions of inquiry to inform the public as to what has happened and why. However, much of the information produced to the Foreign Interference Commission is classified in its nature, and we'll hear more about that in the presentation in the afternoon. And its disclosure could prejudice national security. So the Commission must find a balance that informs the public without jeopardizing national security. The terms of reference specifically require that the Commission maximize public transparency, but take the necessary steps to protect national interests. The terms of reference also mandate in Clause D these public hearings to help achieve the right balance. In conducting its work, the Commission has certain powers, as I mentioned before. It can summon witnesses, it can require them to produce documents and things that the Commissioner deems necessary to the inquiry. It can receive and review any relevant classified document, and this is set out in our terms of reference. It can hire experts, clerks, reporters, assistants, and counsel to assist the inquiry. And finally, it can hold public and in-camera hearings. Now, we recently concluded the standing phase of the Commission, and some members of the public may be wondering what that's all about. So we thought we would give a little brief explanation. Standing means an opportunity to participate directly in the proceedings with certain rights. Standing is given to those that can contribute to the work of the commission and have either a substantial and direct interest in the subject matter of the commission, or have some unique experience or expertise that is likely to provide the commission with assistance in its work that it could not otherwise get. Now, each commission determines how it would like to establish standing, and if there are different categories of standing. In this commission, there are 3 types of standing. A party refers to an entity with standing in all or part of the factual inquiry. An intervener has standing in the factual inquiry and is usually an entity or individual with some interest in the subject matter of the commission, but not as direct of an interest as a party. And then we also have standing in the policy phase, which is simply standing at this point. And when we refer to a participant, we're referring to an entity with standing, either party standing, intervener standing, or simply standing if we're talking about the policy phase. Briefly on the role of Commission Counsel. Commission Counsel are chosen and retained by the Commissioner, and they're drawn largely from private practice. Now, the benefit here is that Commission Counsel can be chosen sometimes with respect to the expertise that they bring to the table, particular experience that they may have. Each group of Commission Counsel is different and unique and can respond to the needs of that particular commission. Like the Commissioner, Commission Counsel are independent, neutral, and impartial. They do not take the side of any participant. Commission Counsel do liaise with participants, however, to facilitate their participation. Thank you. Commission Counsel generally conduct the investigation. They request document productions from participants and others. They identify and interview persons with relevant information and potential witnesses. They review documents. They also help to organize the hearings. They lead evidence at the hearings, and they ensure that all relevant information is introduced into the record. Commission Counsel also assists the Commissioner in drafting rules, drafting decisions, and the final report. And as well, Commission Counsel advise the Commissioner as needed. So the parties, interveners, and witnesses have different rights. The parties have full rights to participate, including a right to access documents in advance of the hearing and to question witnesses. Interveners have notice of public hearings, and they have the right to attend public hearings as participants. They may make oral and written submissions as the Commissioner directs. They receive exhibits from the public hearings, and they may have other rights, including the right to question witnesses when that right is specifically granted by the Commissioner. Now, witnesses that are not part of a group that is represented as a participant can have legal representation present when they testify, and they can also ask for any exceptional measures if needed, for example, to remain anonymous. Now, a public inquiry would not be a public inquiry without public involvement. There are different ways in which the public can get involved in the Commission's work. The first is by attending the public hearings. So we know that there are people attending virtually on Zoom. There are people watching the hearings that are being live streamed from the website. And there's also people here in the room, and we would encourage the public to attend the hearings either online or in person. We welcome you here at 395 Wellington. We also have the Commission's website, which already has a lot of information on there, including the rules of practice and procedure, rules of standing and funding, all of the orders in council that I mentioned, the terms of reference. all of the decisions that have been released so far. And there will be more information on the website forthcoming, including a schedule of proceedings, policy papers as they are developed, and all of the exhibits that are entered into evidence at the hearings. The Commission is also developing a public consultation process to hear directly from affected Canadians and those who want to provide information to the Commission. And as the Commissioner mentioned this morning, we have established a confidential email address for individuals who have confidential information to share with us to get in contact with the Commission. That is a brief overview of commissions of inquiry and the Foreign Interference Commission. Thank you very much.
Thank you, Maître Rodriguez. We are a bit ahead of time, but I think everyone will be happy to have a bit more time for lunch. So we'll break for lunch and we'll come back at 1:45. Thank you.
Order, please, à l'ordre. The hearing is in recess until 1:45. La séance est en pause jusqu'à 1h45. The commission will begin in 1 minute. La commission débutera dans 1 minute. Order, please. À l'ordre, s'il vous plaît. The sitting of the Foreign Interference Commission is back in session. Cette séance de la Commission sur l'ingérence étrangère a repris.
Good afternoon. So our next presentation will be made by Gordon Cameron. He's also Commission Counsel. So Mr. Cameron, if you want to go at the podium, please.
Good afternoon. As the Commissioner mentioned, my name is Gordon Cameron, and the title of this presentation is the Foreign Interference Commission and Classified Information. And one thing to say at the outset is that this whole week is about that topic, and indeed, tomorrow we will have a series of a panel of academic experts. The next day, former senior public officials in the national security space, and then current incumbent officials and a minister. So there will be detailed and at different levels, academic, practical, and current working discussions of this topic. What is happening this afternoon is an overview to help prepare everybody, both for listening to what's going to come up in the week and for understanding how the Commission is handling the issue of its management of classified information. And so if there are questions that occur to you out of what I'm saying this afternoon, please save them, because they're probably going to be answered by what you're going to hear later in the week. If there's something else at the end of the week remains unanswered, you can, as Ms. Rodriguez said, send us an email. But this will just be a very high-level overview of the Commission's work with classified information. And the topics we're going to discuss are, the table of contents looks quite predictable. We're going to start with some definitions and terminology, and that's not insignificant because the Commission has noticed, both in the input it's getting from parties and in coverage by the media, that the definitions and terminology sometimes do matter to understanding properly what's going on with the Commission's work with classified information. We're going to talk about what classified information is, why we use that term, and then how the Commission works with classified information, how we're handling it both mechanically and from issues of policy. And then we're going to talk finally about the particular type of information, classified information, that the Commission is noticing is coming to its attention in the foreign interference context as opposed to some other threat that might also generate classified information. Now, at the risk of oversimplification, it is quite useful to make a reasonable simplification and simply talk about classified information. You will see in the documents to which you've had reference already and that will come up later in the hearing, the expression sensitive or potentially injurious information. That's language out of the Canada Evidence Act. We have a very complete analysis of that for you tomorrow. And also there's another expression you might have seen if you've read the Commission's terms of reference, and that is information whose disclosure could be injurious to the critical interests of Canada or its allies, national defense, or national security. That phrase appears in this Commission's terms of reference in the Order in Council establishing the Commission. It is derivative of language in the Canada Evidence Act, but it is custom for us. It was made specific for this Commission. And the reason I'm introducing these concepts under the discussion of classified information is in effect to say you needn't be distracted by the more technical terms for the purposes of this discussion, or frankly for the purposes of most of your understanding of this Commission's work with classified information, because that expression, classified information, will cover, certainly for practical purposes, all of the work that we will be doing and all of our discussion when you're making submissions to the Commission or when you're trying to analyze the information that you're seeing. There will be times when you will see the lawyers descend into the more technical language out of the legislation or out of the terms of reference, because there are places where it could matter that the actual technical terminology from the legislation be used. But for our purposes, we're going to be well served just with the expression classified information. And the topic of this day or this week, we've called national security confidentiality, which is an expression those of us who work in the field are very familiar with. It is the umbrella term for those situations in which classified information is necessary, and typically where it interfaces with litigation or with the public or something, and there is a need for confidentiality, that is classification of information for reasons of national security. So this is what we call our NSC week, or our National Security Confidentiality Week, to talk about these terms. Information is classified by the government when the government, and it is classified by the government, by the way, it is exclusively the province of the government to classify information. And it does that when it assesses that it's necessary to restrict the disclosure of the information, and importantly, both within the government and outside the government, in order to protect some aspect of the Canadian national public interest. Now, that might seem fairly trite, but there's a fair bit packed into that paragraph, and as we'll see when we move into some of the subdivisions of this, there are different levels of classification, so not all classified information is the same. And predictably, it follows a range from merely confidential, and I don't want to understate the potential significance of confidential information, but it is at the lower level of sensitivity to what I've called here very, very secret information, which can be at the most sensitive information that the government classifies. And the differences in the levels, and we're going to look at several of those levels and ascribe some qualities to each of them. But what you'll see in the next few slides is that the differences in the levels are driven by the different levels of harm that it is feared could arise from the disclosure of the information outside of the permitted audience. So that could be outside of a government department, outside of a very small group of people within a government department, outside of the government itself, to the public, to other nations, potentially to our adversaries, etc. So all of these things are taken into consideration when the government is deciding at what level it should classify information. Now, unhelpfully for the vocabulary here, the first category I'm going to talk about is technically not classified information. It's protected information, but functionally, we have to approach it at the same level. It still is information that the government has decided needs to be controlled in its circulation, needs to have restricted access. The difference between protected information and classified information is that protected information pertains to situations in which the harm from disclosure would be to an individual, or at least something less than the national interest, than Canada's national interest. It's important because the Commission anticipates receiving a fairly substantial volume of protected information. That doesn't mean that the protection of the information isn't significant, because of course there could be very serious harm. There are levels within protected information, one of which is very serious harm to an individual. So it could still be critically important that the information remain confidential. It just doesn't affect the national public interest at the federal government level. Then, so if you move from protected information into what technically is called classified information, there are three categories: confidential, secret, and top secret. And as I said before, these categories are established based on the anticipated harm that could come from disclosure outside the audience for which the information was assembled. So confidential information is disclosure that could cause some injury if disclosed, and injury to the national interest. Secret information, that is information that gets the classification secret, is information the disclosure of which could cause serious injury, again, to the national interest. And finally, top secret information is information the disclosure of which could cause exceptionally grave injury to the national interest. And if you were to look at the government policy on security, those adjectives would be applied in exactly that context. Though we haven't made these up. Those are the exact terms that are used by the people who classify the information to decide whether they, on looking at a document, should be classifying it as confidential, secret, or top secret. And then a complication that we'll add here, but it's important because it might arise in the context of some of our discussions, is that within top secret information, there are further categorizations for information that is, and the expression I've used in the slide is ultra sensitive. So it is at least top secret, but a decision has been made by the people who have assembled the information that it should only be disclosed within an even more restricted audience than would otherwise be available with top secret information. So sometimes this is called compartmentalization or control systems that are used even with top secret information. And though there is nothing technically above top secret, the expression top secret and above has just come into the parlance as the way of describing both top secret information and the various subcompartments of especially sensitive top secret information that might arise. A point that I'll just digress on briefly here is that when we're talking about a document and its classification at the confidential, secret, or top secret level, that designation of the document doesn't mean that every word in that document is at the top secret level. That is, that the disclosure of any, say, sentence in that document could cause exceptionally grave harm to the national interest. It could mean that one sentence in that document could cause that type of harm, and the rest of the document might, I'll say only, but this is still substantial, only be at the secret level or perhaps not even necessarily classified on itself. But when a person's creating a document and that document is what is going to be circulated, if there's one item of information in there that is at the top secret level, obviously the whole document has to be classified as top secret. I mention that because when we come later to discussion of things like redactions, that fact that not the whole document needs to be top secret, that doesn't flow necessarily from the designation or classification of it as top secret. Now, one of the points we wanted to make sure the parties and the public were completely alert to is that this commission has access to all of the categories I just described of classified information, obviously protected and classified information, protected, secret, top secret, any compartmentalization, any information relevant to foreign interference that the Commission has requested from the government will be given to us regardless of its classification level, regardless of its compartmentalization, regardless of its otherwise restricted information within government. There might only be 3 people within government who are entitled to see the document, but the Commission will see it. So there's nothing, no information withheld from the Commissioner or Commission Council on the basis that it would be, that it is classified or otherwise protected on grounds of national security. Now, this didn't come about without a considerable amount of work on the part of the Commission and the government and everybody else to make it possible for the Commission to have this unrestricted access to classified information. And so one thing that, and for those of you who are wondering why the hearings didn't start the day after the order in council came out, one thing that had to happen was that the Commissioner and all Commission Council had to be security cleared to the highest levels and indoctrinated to all of those top secret and above compartmentalizations of, so that the Commissioner and all Commission Council would have access to all of the classified information. There will be controls within the Commission about who sees what, but we are at least all, as the lawyers would say, prima facie qualified to see that information. Another thing that had to happen before we could have you here today and get started on the public hearings is that the Commission had to have premises that it could examine this information in. And those premises are not just any boardroom in a building in Ottawa. They have to be specially constructed so that they are both secure as to access, secure as to potential eavesdropping, all of the computers, everything has to be unhackable. So there's a huge infrastructure program that has to take place. When you get literally a pop-up entity like a commission of inquiry that is suddenly going to be given access to the most sensitive information that the government holds, there's an incredible machine that had to come into place to get premises, to get computers, to get infrastructure, to get personnel properly cleared, etc. All of that has happened. We're well underway in the course of the work, but that is one of the consequences of the fact that the Commission has access by virtue of its terms of reference to all of this information. Another consequence is that because we have been given this information, all of us, the Commissioner, Commission Council, any staff who have access to the information, are by law, but we also swore oaths, but we are by virtue of at least the Security of Information Act and some other legislation, permanently, as in until we die, bound to secrecy for all of this information. Now here is what you might call the inflection point in the discussion, because so far we've been talking about the unrestricted access that the Commission has to all of the classified information. And what has to be understood to appreciate the way you are going to see the Commission's work unfold over the coming months is that there's a difference between having access to classified information and having the authority to disclose it. And you might even put that more categorically than there being a difference between them, which is having access to classified information accords no authority to disclose it. And as a matter of fact, as I was just saying in relation to the Commission being permanently bound to secrecy, often access to classified information is prohibitive of ever being able to disclose it because you are in that category of people who are not allowed to disclose. And this is not just something unique to public commissions of public inquiry or this commission, obviously. There are other entities out there that work with these same restrictions, and CIRA and NCCOP are good examples. You also encounter this in some tribunals. Courts sometimes have similar issues where the commission has access to classified information, but no authority at all to disclose it to the public, or indeed, as government controls itself within its various departments, the commission doesn't have authority to disclose it to people in the government who aren't authorized to receive it. So analogous to that, analogous to the lack of authority to disclose it, is the commission does not have any authority to unilaterally declassify information. So we can't look at a document and say this is classified as top secret, but in our view, it only needs to be classified as secret or confidential or not classified at all. The commission has no authority to render information disclosable unilaterally. And so the question you might ask is, what do we do then? You know, what good is it that we have access to all of this classified information in a public inquiry if the Commission doesn't have any authority to disclose it? And the answer is that because of the restrictions on disclosure, what the Commission will do, and what other commissions have done in the past, is make representations to the government to achieve maximum transparency, which is, of course, within the Commission's terms of reference and something that is central in the way all of the work will be done. Now, I'm going to look here at several of the tools that we use to make representations to government and try to give some examples, or at least elaborate for you about what it means for us to do this kind of work. I'm going to start, this could have warranted, in retrospect, a slide of its own, but just so that you understand how we get to this stage where we've got classified information and the Commission has an interest in disclosing some part of that document to the parties and to the public. The process would start with the Commission identifying some, and this would be a rolling process, but some documents that it thought important that the parties and perhaps ultimately the public have to participate in the Commission's work. And so a request, and bearing in mind the Commission is looking at the totally unredacted document. It is looking at the bare document with all of the information in it. The Commission would then send off a request to the government. Here are 10, 50, 100, whatever number of documents that the Commission has identified as appropriate for disclosure to the parties or the public. Would the government, render them disclosable? So here they are in their bare form. Would you send them back to us in a form that we can then disclose to the public? And you've seen, if you've looked at the consultation paper and the results of that, what that looks like when it comes back. Sometimes the document is almost completely redacted. Sometimes it's almost completely disclosed, depending on the volume of classified information in that document. So if we then look at that stage, in that sequence of events, picture the Commission has now received back a batch of these documents that it wants to disclose to you. And the documents say it's got a document with 4 lines of redaction in it.